Good afternoon, everybody. I was pausing for a minute just to allow people to come online, but the number of attendees seems to have stabilized, so I'm going to start. I'm Andrew Peebles, for those who don't know me, and I'm going to give the talk on vicarious liability with Tom Bourne-Arton this afternoon. I was very flattered to see the number of people who'd signed up. It must be Tom's silver tongue. The topic in question is the difficult and nebulous topic of vicarious liability in the light of the recent Supreme Court decisions of Barclays and Morrisons, which a number of us have been waiting for with bated breath. Tom is doing the screens for me, so he will be clicking through them as I go. Thank you, Tom. There is a Q&A button, which should be at the very bottom of your screen, and you can fill in questions as we talk. Tom and I won't be looking at those, so our Q&A screen is closed down whilst we're actually talking. But we'll open them up when we've done, and we will go through questions so far as time limits permit. Good. Well, as you all know, the Supreme Court have recently given a pair of judgments in order to deal with the separate questions that arise in considering vicarious liability. Those questions are set out on the slide. For vicarious liability to attach, two considerations have to be met. First, what sort of relationship has to exist between an individual and a defendant before the defendant can be made vicariously liable in tort for the conduct of that individual? That's the first question, and that's the question which Tom will be addressing shortly. Secondly, in what manner does the conduct of that individual have to be related to that relationship in order for vicarious liability to be imposed on the defendant? And that's the topic on which, broadly speaking, I will be talking after an introduction. The first of those was considered in Barclays, and the second of them in Morrisons. Moving on, the court had previously attempted a more definitive approach to these long-standing issues in Cox and Ministry of Justice, and in Muhammad and Morrison supermarkets. You've got to feel a bit sorry for Morrison supermarkets, who feature in two of the Supreme Court decisions, but there they are. But very briefly, although in both of these decisions they purport to be applying the common law as it's always been, in reality, the general feeling is, I think, that the newest two decisions, Barclays and Morrisons, amount to something of a reining in of what was looking like a continued creep of vicarious liability under both sets of questions. As ever, where the court are pretending that they've always said the same thing, it becomes a little bit vexed. It's, I think, perhaps somewhat like, you'll remember Mitchell and then Denton Hall, where with the court in Denton Hall saying, nothing's changed at all, but just to make things absolutely clear, this is what we were always saying. But with the result that before Denton Hall, relief from sanction was more often than not refused, and after it was more often than not granted. I think that there's been a change in the playing field, perhaps not quite of that nature, but certainly a tightening up of where liability will accrue. And we'll discuss that in a little bit more detail as we go through it. First of all, I just want to set the scene. I'm quite keen on setting the scene, and I'm quite keen on setting the scene particularly in areas like this, which are intensely politically driven, where decisions are often hard to predict and possibly even hard to explain. Setting the underlying basic framework of rules is, I think, helpful to make sure that the questions are being approached in the right way. And there are three paradigms. You'll all be entirely familiar with them. Some of the earlier case law perhaps elided some of these categorizations from case to case. So these were all considered in Woodlands, which, as you'll know, was a case in which we were primarily concerned with non-delegable duties. It's an independent contractor who was doing swimming lessons for a school, and regrettably somebody drowned. There was negligence, but not by anybody employed by the school. The case principally deals with non-delegable duties. In the course of doing it, and particularly in the Court of Appeal, they tried to draw lines between the types, the basic types of tortious liability. The basic type of tortious liability is that a person is liable for his own act or omission, which amounts to a tort against another person, the claimant. In terms of negligence, that means a breach of a duty of care owed by the defendant to the claimant. The acts of another person may be a breach by the defendant, by the usual rules of attribution. I'm not going to go into those. There are two main exceptions to that principal approach. And for those exceptions to remain exceptions, they do have to be applied relatively sparingly so that the exceptions don't eat the rule. One is a non-delegable duty of care, and that is not simply a duty to take care in relation to another, but a duty to ensure that care is taken. In those cases, the acts or omissions of an independent contractor may give rise to a primary breach because there will have been a failure to ensure that that independent contractor took care. The next exception is the one which we're dealing with, which is vicarious liability, by which a defendant is held liable for the tort of another. And as I've written, it's important to note a defendant may or may not be in breach of any duty owed by it. It is in effect a species of strict liability, because it is liability for a duty owed by the employee or quasi-employee to the claimant. And the breach of that duty is the breach by the employee or quasi-employee. It is not the defendant's breach. And that, I think, is sometimes overlooked because in many cases it really doesn't matter how you get to the result. But in those cases where you're close to the edge, it will very much matter. And I think that you should bear in mind when considering vicarious liability, the basic type of liability. It may assist if all that is relied upon are circumstances which arise simply out of the basic duty of care. It's relatively unlikely that those circumstances are going to be sufficient for vicarious liability. Right, with that start, I'm going to pass straight over to Tom to answer the first question, which is the expansion of the doctrine of vicarious liability beyond strict employment situations. Tom?
Thank you, Andrew. I was just reaching for my unmute button, which I fortunately have found, hopefully. Thank you, Andrew, for setting the vicarious liability scene so eloquently. And as Andrew has pointed out, I'm going to speak to the first question, which one should consider when considering whether or not vicarious liability should attach to a defendant. And of course, as set out on the slide, this is what sort of relationship has to exist between an individual and a defendant before the defendant can be made vicariously liable in tort for the conduct of that individual. And this was the question that was considered in the recent Supreme Court case of Barclays. But before I get to Barclays, what I plan to do, and what I'm going to do, is just review 3 previous Supreme Court cases which considered this issue as well. The first was Christian Brothers, full title Various Claimants and Catholic Child Welfare Society, but as everybody will know is referred to as Christian Brothers. The second is the case of Cox and Ministry of Justice, and then the third is the case of Arms and Nottinghamshire County Council. And I do this really just to set the scene as it was prior to the Barclays case, just to give it some, just to explain how this area of vicarious liability had been on the move, which clearly it had been, by the fact that you have, in fairly short succession, 4 Supreme Court cases dealing with effectively the same issue. So, looking at the Christian Brothers case, as everybody who's watching this will be well aware, this was a case that involved a number of lay brother teachers who were accused of various abuses. And the question arose as to whether or not the institute to which those brothers were associated could be held vicariously liable for the various abuses that were alleged against them. And the Supreme Court upheld the previous decisions that were made, that the institute could be vicariously liable. In the leading judgment of the Supreme Court, Lord Phillips held at paragraph 35, and then later on another slide I've got paragraph 47, the 2 paragraphs which are routinely referred to and quoted in following cases involving this type of issue. And you'll see on the slide here, paragraph 35 of the judgment, what Lord Phillips says. And I think given the importance that has been held and the discussion that's taken place in relation to this aspect of the judgment is worth just reading it out. What he said was, the relationship that gives rise to vicarious liability is in the vast majority of cases that of employer and employee under a contract of employment, what can easily be described as the straightforward cases. The employer will be vicariously liable when the employee commits a tort in the course of his employment. There is no difficulty in identifying a number of policy reasons that usually make it fair, just and reasonable to impose vicarious liability on the employer when these criteria are satisfied. And just pausing there, I'm just going to highlight the phrase policy reason, because of course, when we come to the case of Barclays, that is what was stressed by the Supreme Court, that what we're looking at here are policy reasons which make it fair, just and reasonable to impose vicarious liability on an employer. And then Lord Phillips set out the 5 criteria. The first being the employer being more likely to have the means to compensate the victim. The second being that the tort would have been committed as a result of activity being taken by the employee on behalf of the employer. The third is that the employee's activity is likely to be part of the business activity of the employer. The fourth is that the employer, by employing the employee to carry on the activity, will have created the risk of the tort committed by the employee. And finally, the 5th criteria was that the employee will, to a greater or lesser degree, have been under the control of the employer. And what you'll see from that, of course, is that the 2, 3, and 4 are very much interlinked. And that has been commented on following this, specifically in the case of Cox, which we're going to come on to. The first one has come under some criticism. That's the fact that the employer has deep pockets. And the 5th one is the one that used to be the main criteria when looking at these things, and it's not been sidelined, but it's certainly been lessened. That, of course, is the question of control. At paragraph 47, Lord Phillips continued that what he'd identified at paragraph 35 were the incidents of the relationship between employer and employee that make it fair, just and reasonable to impose vicarious liability on a defendant. Where the defendant and the tortfeasor are not bound by a contract of employment, where their relationship has the same instance, that relationship can probably give rise to vicarious liability on the ground that is akin to that between an employer and an employee. And that's the thing here, is what we're looking at is either there's an employment relationship in place or there's something that is akin to an employment relationship. And when we come to Barclays, what we then have, of course, is those aspects, those types of relationship compared to a relationship where there is an independent contractor. In Christian Brothers, what the Supreme Court held was, of course, that there was an akin to relationship. an akin to employment relationship. So that was the Christian Brothers case. Moving on to the case of Cox and Ministry of Justice. This involved a prison, and specifically a prisoner who dropped potatoes, or a bag of potatoes, on the claimant, who was working as a catering assistant at the time, causing a back injury. And of course, in no sense was the prisoner an employee of the prison, but it was nonetheless held by the Court of Appeal and then affirmed by the Supreme Court that the Ministry of Justice could and should be held vicariously liable for the actions of that prisoner. At the Court of Appeal, the focus was on paragraphs 35 and 47 of the Christian Brothers case, which I've obviously set out, and specifically those 5 criteria. And you can see on the slide the aspects that were taken into consideration. I'm going to move on to what the Supreme Court held, because of course that is of slightly greater importance, they would say. And what the Supreme Court decision did was it upheld the Court of Appeal's decision, but in doing so, they adopted the Christian Brothers 5 criteria and referred to them, but they went on to clarify them a little bit. Obviously I've touched on this earlier, but what they effectively said is the first criteria, which is the ability to pay, which you'll have remembered from the slide a few 4 or 5 ago, that in of itself is not a ground for imposing liability. So they're distancing the Christian Brothers' first criteria by saying it may be a factor, but it's not the most important factor, and clearly in of itself could not impose liability. They went on to say the 5th criteria, which of course is the one of control, is of less importance than it used to be, but of course still relevant factor, and then made the point that I've already made, which I obviously took from the case of Cox, was that the 2nd, 3rd and 4th criteria are interlinked. And then I've set out on the slide a quote, which obviously summarises the situation in Cox and the result that was then reached. And of course, in this case, what we have is another akin to an employment relationship in place, which meant that it was just and reasonable for the Ministry of Justice to be held vicariously liable. Arms is the 3rd Supreme Court case I want to refer to before coming on to the case of Barclays. This was a somewhat difficult case to grapple with in many respects. In summary, having considered Christian Brothers as discussed in Cox, the Supreme Court pointed to said effectively that the county council could be vicariously liable for torts committed by foster carers. And of course, clearly in this situation, there's no employment relationship that is in place. But what they did is they applied the 5-stage test set out by Christian Brothers and as commented on by Cox. They didn't deal with them in the 5 criteria order, but this is what they said. And in A, obviously, we're looking at the appellant. What they said was the appellant's foster parents could not be regarded as carrying on an independent business. Well, that's quite an interesting point to take on, because, of course, they're distancing this case of foster parents from situations where there is an independent business conducted. And then went on to say the torts committed against the appellant were committed by the foster parents in the course of an activity carried on for the benefit of the local authority. So that's the 2nd and 3rd criteria intermingled. In terms of risk creation, they said that the risk was created by the council. That's obviously the 4th criteria. And at C, what I've got here is the local authority exercised powers of approval, inspection and supervision, etc. And what the Supreme Court were doing at this point is looking at the control that was imposed by the council on the foster carers, and saying that obviously there was an element of control which pointed to an akin to employment relationship. And then finally they looked at cost, and they gave this some weight, actually, effectively saying that foster parents would have insufficient means to be able to meet a substantial reward of damages arising from an assault or an abuse type situation case, whereas local authorities clearly do have the money to compensate those victims of abuse. So that's what happened in Arms. So it was against this background that various claimants in the case of Barclays said that Barclays Bank ought to be vicariously liable for the actions of an independent contractor who was a doctor conducting medical examinations. And effectively, what was argued on behalf of the claimants was that when you look at the 5 criteria, you create a situation where it is fair, just, and reasonable to impose vicarious liability. And the judge at first instance agreed, and so did the Court of Appeal. And the Court of Appeal affirmed the decision at first instance that Barclays were vicariously liable. And in doing so, they applied Cox and Mahmood, and they looked at the 5 stages, considered them in detail, and said that as a result, Barclays Bank are vicariously liable for the actions of the doctor. Lady Hale, in the leading judgment, which was unanimously agreed to in the Supreme Court, disagreed and reversed those decisions. She found, and the Supreme Court held, that Barclays Bank not liable vicariously for actions of the doctor who they found, and it was accepted effectively, was an independent contractor. So obviously in doing so, she overturned the previous decisions. She held in her judgment that there was nothing in those 3 cases that I've just referred to, various claims of Catholic child welfare, the Cox Ministry of Justice, and Arms, that would suggest that the classic distinction between employment and relationships akin to employment on one hand, set against those of an independent contractor on the other. So there's nothing to suggest that the difference between those types of relationships had been eroded by those previous Supreme Court cases. And she went through some of the history of independent contractors not being held liable, and then looked at the 3 cases and explained why there was nothing in there that eroded that previous position and long-standing position that effectively people are not liable for the acts of independent contractors. And this is is in my view, the key paragraph which sets out what she was saying in the case of Barclays. It was paragraph 27, where she said, "The question therefore is, as it has always been, whether the tortfeasor is carrying on business on his own account, or whether he is in a relationship akin to employment with the defendant." She went on, in the doubtful cases, the 5 incidences, or obviously what we earlier called criteria, identified by Lord Phillips may be helpful in identifying a relationship which is sufficiently analogous to employment to make it fair, just, and reasonable to impose vicarious liability. Although they were enunciated in the context of non-commercial enterprises, they may be relevant in deciding whether workers who may be technically self-employed or agency workers are effectively part and parcel of the employer's business. She went on, but the key, as it was in the Christian Brothers, Cox and Arms, will usually lie in understanding the details of the relationship. Where it is clear that the tortfeasor is carrying on his own independent business, it is not necessary to consider the 5 instances. So the point being made here is that if it's clear that there's an independent contractor, then you don't need to look at the 5 criteria of the Christian Brothers 5 criteria to identify whether or not there is an akin to employment relationship, because we know that there isn't. There is an independent contractor, and that's the end of it. And in that case, the defendant would not be vicariously liable for the acts of the independent contractor. So effectively, what you now have to do is you have to break the first question into 2 questions, 2 sub-questions. The first being whether or not the tortfeasor is an independent contractor, or whether he is an employee or somebody with a relationship which is akin to an employment contract. If it is an independent contractor, then that's an end of the matter. If not, then you look at the 5 criteria set out by Christian Brothers and decide whether or not there is a sufficient relationship to impose vicarious liability. What does that mean going forwards? Well, I suspect that there will be litigation on whether or not it is clear that there is an independent contractor in place. Because of course, what Lady Hale said is where it is clear there's an independent contractor situation, then effectively that's an end to it. But of course, there will be situations where it's not clear. and you'll have to determine that by looking at the facts of the case, as is often the situation. One way to answer the question whether or not somebody is an independent contractor is looking at what Lady Hale herself said in Barclays, which is the question is whether the tortfeasor is carrying on business on his own account, or whether he is in a relationship akin to employment with the defendant. She also referred to the judgment of Lord Justice Ward in English Province of Our Lady of Charity, where he said an employee is one who is paid a wage or salary to work under some, if only slight, control of his employer in his employer's business for his employer's business. The independent contractor works in and for his own business at his risk of profit or loss. So that's two sort of good parts of the Barclays case that you can look at to decide whether or not, in any particular case that you have, whether the person is an independent contractor or not. And if the independent contractor is working for his own business at a risk for his own profit or loss, then the indication is most likely that it'll be an independent contractor, and vicarious liability will therefore not be imposed. Just finally, what does that mean for the Barclays Bank case? Well, the doctor in question was an independent contractor, and therefore Barclays were not vicariously liable for his alleged assaults. And I've set out on the slide here the reasons for that. But given the time constraints that we have with webinars, I'm not going to go through that in any detail, but those are the reasons why the doctor was held to be an independent contractor. And that, in a nutshell, deals with the first question. And what Andrew is now going to do in a much more smooth and clear and coherent way, no doubt, is consider the second question.
Yeah, hopefully I'm unmuted, and hopefully I won't disappear again. Those of you who are eagle-eyed may have noticed that I managed to have the absolute classic of being bumped by my mother-in-law's incoming message out of the meeting altogether. Anyway, on to the second question. I'm going to approach it very slightly differently by starting off with the tests in the two leading Supreme Court cases and then going through those cases. So I'm going to start with the test that Lord Toulson described in Mohammed. I haven't given the paragraph numbers because I've slightly simplified it. In the simplest terms, the court has to consider two matters. The first question is what functions or field of activities have been entrusted by the employer to the employee, or in everyday language, what was the nature of his job? As has been emphasized in several cases, this question must be addressed broadly. And then secondly, after doing that, the court must decide whether there was a sufficient connection between the position in which he was employed and the wrongful conduct to make it right for the employer to be held liable. And he arrived at those tests after, as was typical with Lord Toulson's judgments, after an extensive review of the history of the policy. But in the end, in order to do justice in the particular case. And in the particular case, the facts were Mr. Khan worked at a petrol station as an attendant. His job, and this was the description picked upon by Lord Toulson, was to keep pumps and the kiosk in good running order and to serve customers. And of course, it's the serving customers, which is a very broad description of the task upon which he was employed or his job. And in that context, the victim, I just commented the victim because he was dead by the time that the Supreme Court came to consider it, asked for some documents to be printed from a USB. Mr. Khan was affronted by this request, which was made to him as the person standing behind the counter at the time, and refused in strong terms. And encouraged him to leave promptly. The victim did go back out, and got back into his car, which was by the air pump within the premises. He was followed by Mr. Khan, who assaulted him in his car, telling him never to come back. And it's curious, you'll see why when I get onto a description of how the tests really apply. Each aspect of the particular facts which are picked out by the Supreme Court assist in determining what the final result will be. Details are really matter in this particular forum. So, answering the two questions, the duties attending to customers and responding to their inquiries was what put Mr. Khan in contact with the victim. So that gave him some sort of responsibility to look after customers and to respond appropriately to their inquiries. So that the start of the incident, his response to the request, was within the field of activities assigned to him. The question was the conduct still sufficiently closely connected? And Lord Toulson went on to say that there was an unbroken sequence of events between the start of the incident and the assault. And in telling the claimant never to come back, he was purporting to act about his employer's business, which he reinforced by violence. You may think that is in itself something of a characterization. If you did, I would agree. His motive was likely to have been racist, said Lord Toulson, probably, but that was not relevant in the circumstances. The courts went on between this and Morrisons to find that a number of instances in which they used Lord Toulson's language to arrive at a result where liability accrued. Lord Reid, who had been previously involved in some of the earlier cases, went through what the Court of Appeal had done in the case of Morrisons, and used that as an occasion to correct the Court of Appeal. He used the device of correcting the Court of Appeal's approach as a manner of critiquing Lord Toulson's judgment, which of course he wasn't actually doing. Lord Toulson was of course completely correct, but nevertheless he pointed out how a literal application of the words used by Lord Toulson may arrive at the incorrect result. Instead, he returned to the test previously applied, the rather broad test previously applied in Dubai and Salam, Dubai Aluminium and Salam. Perhaps the best general answer is that the wrongful conduct must be so closely connected with the acts the partner or employer was authorized to do that, for the purposes of the liability of the firm or the employer to third parties, the wrongful conduct may fairly and properly be regarded as done by the partner while acting in the ordinary course of the firm's business or the employee's employment. The first thing I'd like you to note from that is that we're returning to a criteria of fairness, a criteria which was also emphasised by Lady Hale in answer to the first question, a criteria which notoriously may be seen to permit judges doing whatever the heck they want. Tom, next slide, please. The facts in this particular case were that an employee, Mr. Skelton, was an internal auditor for Morrisons. Amongst his no doubt multifarious tasks, one of his tasks was to compile employee data for onward transmission to the defendant's external auditors, KPMG. So what happened was KPMG said, well, we need all this material in order to carry out our external audit. He then has to compile all of that, collate it, and send it on. He had had disciplinary action taken against him in relation to, I understand, a relatively minor matter, and had as a result developed a grudge against his employer. So when he accessed the payroll data on a huge block of employees, he correctly passed it on to the external auditors. He also took the opportunity to download a copy of that data onto a personal USB stick. He created a false email address using the details of a colleague who he was going to try to frame, and he bought a pay-as-you-go phone. He uploaded the data onto a publicly available website and then created some links on that website using the phone and the USB stick and the email account, and then deleted the material and the email account. The leak was in fact caught, and the courts were partly influenced by the fact that Morrisons had done absolutely everything they could to try and deal with the results of the leak. It was held, applying the test that I've already gone through, that there was no sufficient close connection. In this regard, the intent to harm his employer was relevant. So the purpose of the act was relevant, not, so there's it was necessary to explain why it wasn't relevant in Muhammad. And in Muhammad, it wasn't relevant because the close connection was established without the need to refer to purpose. It was already sufficiently clear simply by looking at the field of activities and the relationship of what was done and what was purported to be done to that field of activities. And so it didn't matter. In many cases, however, and particularly in this one, it did. And it makes some sense. It, as the court pointed out, would be odd if you can do an act, the very purpose of which was to sabotage your employer, and nevertheless for the employer to be held liable for the damage caused by the employee. It was not enough, as the Court of Appeal thought, that the field of activities involved collating data and disclosure to KPMG. They thought that was pretty obvious, that disclosure of data to somebody else was pretty similar to disclosure of data to KPMG, and that was a close enough connection. No, this was merely the opportunity to commit the tort. It was not enough that the act was broadly of the same kind as that which he was authorised to do. He was on a frolic of his own, engaged only in furthering his own interests as distinct from those of his employer. The frolic of his own is a return to a time-honoured phrase for setting apart those acts which will be regarded as sufficiently close to the employment to be regarded as part of it, and those acts which will be regarded as personal to the employee, and for which no vicarious liability will attach. Next slide, please. What to make of these two tests? I suggest that they can, in fact, at least partially be reconciled. In my view, at least, the two stages set out by Lord Toulson will be helpful in all but the most obvious cases. It will be helpful to identify the field of activities first and to identify that broadly. Obviously, you have to identify it broadly because if you ask yourself the narrow question, was it part of his job description? The answer will almost invariably be no, where it's an intentional tort, because it's almost invariable that it's not going to be authorised, self-evidently, with assaults and sexual abuse. So that's obviously not the right way of framing the question. This part of it, you can identify it in the test set out by Lord Reid as what were the acts that he was authorised to do. So this is concerned with actual authority. What was the scope of the actual authority of the employee? There's a key extra to this, which is, again, in my view, it's pretty clear that the nature of the identification of the field of activities can itself go a long way to helping to answer the question which follows of close connection. so the courts have been much keener to find, or have found it much easier to find a close connection, where the nature of the field of activity involves conferring some, by way of direct authority, some responsibility on the tortfeasor vis-à-vis the claimant. So in the sexual abuse cases, you have a direct responsibility for the welfare of children or young people. You have giving a position of trust which may be misused. You have, in managerial cases, a responsibility to your employees, which is part of the managerial task. For the customer, you have some responsibility to the customer to look after the customer. The more that responsibility is etiolated, the harder the court will look to see whether there's a close connection. But palpably, where you have put somebody in a position of serious responsibility, and within that obligation of care, there has been a complete failure to take care by sexual abuse, for example, it becomes pretty easy to establish the link. Sorry, Tom, back one. You then go on to evaluate closeness of connection. And I'm just going to skip to the next point, which is purported authority. Purported authority does seem to me to be quite useful. And that's because the evaluative task which is being taken up, Lord Reid said rather piously, I think, at paragraph 20 of his judgment, that of course it wasn't a free-for-all, that judges would have a look at previous cases and that they would develop the answer in a close and principled way. But the questions we've been asking are pretty broad. And just by way of a very short example, in a House of Lords and 2 Supreme Court cases, one case, Warren and Henley's, have had 3 separate explanations provided for the result being the right result. So, I mean, Lords Millett, Toulson, and Reid have given separate, and in the case of Lord Millett, who gave an explanation in Lister, and Toulson, irreconcilable explanations, which give you some sense as to how the process of evaluation may involve characterization, which may allow different results to be arrived at by different people looking at the same facts. So within that, how do you manage to apply these broad tests so as to explain the results which have been arrived at in different cases? And the courts have found the metaphor of whether you're metaphorically wearing the employer's hat, the employee's hat, to be a useful one. Ostensible authority will often provide an answer. So, for example, Bellman, which it was a case of a senior manager out at drinks, it didn't matter that he wasn't at work. His managerial responsibilities continued, and he was purporting to exercise those managerial responsibilities when he first berated his employees and then beat up one of them. Mohammed, we've already seen that Toulson described the end of it, the end of the activity when the assault took place, as being part and parcel of Mr. Khan purporting to act on behalf of his employer. And in Bernard, one of the shooting cases, the use of the revolver provided to the policeman followed very shortly after his identifying himself as a policeman, and therefore he would have been understood to have been acting as such. So now moving on. Thank you, Tom. A temporal gap can be useful for identifying a departure, but as we've already canvassed, that will depend very much upon the nature of the role which has been addressed. So in Bellman, for example, it didn't matter that it was outside work. It didn't matter that the work drinks had formally ended. the nature of his role was such that it was easy to extend. Much the same may be said of the perhaps slightly far out case of Haringey recently, in which the court found that sexual abuse after a pupil had ceased to be a pupil were nevertheless still acts for which the school was vicariously liable, because the effect of the abuse of trust was still in play. On the other hand, you have cases between employee and employee where temporal or causal connection will be more useful to identify that there has been a break. So the case that I referred to earlier, Warren, the customer had returned with the police officer, and it was easier to infer in those circumstances that the employee in question, who might otherwise have been quite close to the employee in Mohammed, was acting personally out of his own personal vendetta. As I've already said, identifying why the tortfeasor acted will be of assistance, as it was in the case of Morrisons, in certain circumstances. But again, it's important to emphasize that it's quite difficult to tell between the cases in this regard, and it will depend very much, in my view, on the nature of the underlying relationship as to how easy it is to characterize something as being a personal vendetta. Acts between employees, much easier to identify as being a personal vendetta, for example. I was asked a question by email as to whether the case of Graham was still good law. The case of Graham was a case where an employee set light to a fellow employee. It bears a remarkable similarity to one or two earlier cases in which liability did attach, but it did not. And it seems to me that it probably still is a correct case, and it's a correct case because they were regarded as personal acts having regard to the relationship between one employee and another. It wasn't part and parcel of the risks which an employer would have in those circumstances have adopted. It didn't arise simply out of the use of flammable equipment, but because there was, because he used a lighter, because it was the deliberate act of using a lighter, that deliberate act put it outside the scope of employment and inside the scope of personal acts committed one against the other. And lastly, the 5 indicia which Tom discussed in some detail are not going to be useful for determining this part of the case. It would be odd if they were, because then you would simply have to ask one set of questions and it would always provide the answer. I will now go on to questions.
Well, Andrew, I've whilst you were, the reason I may have skipped on what the last slide too soon was because I was trying to multitask, which obviously I am not good at. And I was looking to see how many questions we've had, and we have had a few questions. So what I intend to do is I'll just read some of them out, and then we can discuss or decide who's going to answer them. The first question comes from Gillian, who actually sent an email question to us before the talk started, and I suspect they involve the same case. Knowing Gillian as I do, I suspect that this is probably within the remit of the Employment Tribunal, and apologies, Gillian, if I'm wrong about that. But given the fact that the sexual harassment in Employment Tribunal is also a tort, and despite the fact that it's been enshrined in statute that somebody, an employer, is liable for the employee's actions, I suspect the same considerations apply. What she asks is, in a sexual harassment case, if the alleged harassment took place after the end of a Christmas party, when the senior male invited the junior female to have a last drink in a pub by the station and then sexually assaulted her and thereafter sent disgusting sex texts to her while she was on the train going home, would the employer still be held to be vicariously liable on the basis there was sufficient nexus between the acts complained of and the employment? So clearly we're looking here at your second question, and in a tort aspect, which this would fall under, the question really is whether those acts would be such that the employer would be vicariously liable for. And without sounding too much like the Court of Appeal, I suspect the answer is it'll depend on some more facts here. Obviously, Gillian's referred to a senior male and a junior female. We don't know how similar this case is to the Bellman case, which you've referred to. But obviously in Bellman, what was happening was the manager had his managerial decision questioned by the person he ended up assaulting, which was one of the relevant features. I don't know, Andrew, if you've got anything you'd add in relation to this particular situation. It seems that it may be outside of vicarious liability if it is in a different setting to where the Christmas party was held and not related to any kind of managerial decision. But of course, we don't know all the full facts.
Yes, I mean, I don't know the difference in employment law, and I know that there is a slight difference if you were to approach it solely from the question of ordinary civil liability. I would have to say you would have to look quite closely at the particular facts and the nature of the managerial responsibility and whether that could be said to have extended to the acceptance of the invitation to go on to the with the manager, and we couldn't really characterise that without much more facts to scrutinise the question.
The second question we've been asked is by Mark, who asks a question in relation to the first consideration of vicarious liability, the one that I spoke about. And he asks, what would be the situation where a charity A recruits and places a volunteer with another charity B to undertake activities controlled by B? He says that charity A has no control over the volunteer's activities as a volunteer, which is controlled by charity B. And then asks, where would the vicarious liability lie in that situation with A or B? To which my answer would be to look at the 5 criteria, because this is clearly not an independent contractor type situation. So we then need to decide whether or not, when we look at the Christian Brothers 5 criteria as discussed in the case of Cox, whether or not there is an akin to employment situation. I suspect the lack of control by charity A means that there isn't an akin to employment between A and the volunteer, but of course some will depend on the exact way that he was, the volunteer was placed. But I suspect that really it'll be with charity B, because if they have the control over what the volunteer is doing, and it'll be presumably in pursuant of charity B's undertaking and their effective business or charitable activities, I suspect that the answer is that it'll be charity B that would be held vicariously liable. But without sounding too much like a Court of Appeal judge, which of course I have no aspirations towards, a lot will depend on the facts of the case.
I agree. The question as framed, the answer is B. If there's genuinely an absence of control, that is sufficient to negative liability on A. But actually, the complete absence of control is relatively unusual. Yeah, which is why I agree with Tom.
Which is reassuring. We have another question from somebody who is an anonymous attendee, so we don't know, we can't say exactly who it's from, but it's for you, Andrew, because it says second question presentation. Regarding the issue of connection between the position to which employed and the wrongful conduct, if dealing with, say, a temping agency, I assume you'd be looking at the job description of the company to which the agency worker had been assigned. What if the job description differed to the reality of the job duties? So there's a couple of questions in there.
Yes, you would look at the job description of the company to which the agency worker had been assigned. That would be the job that he was actually carrying out. But in answer to the second part of it, it's the reality of the job duties which is key, When I said earlier, you addressed the question broadly. We go back to the earlier case of Ilke and Rosen Plenty, which are discussed in the Supreme Court cases. You do not simply look at the job duty list as in the contract and say that's all that you were authorised to do. You're looking much more broadly at what was the nature of the reality of his undertakings. Otherwise, as I said before, you're going to arrive at almost invariably at the result that authority wouldn't extend to the acts complained of.
Yeah. And I note the time, we're under a cut-off of 5:30. There's probably time for just one quick answer to the following question, again from an anonymous attendee, saying, is an agency relationship akin to an employment relationship so as to attach vicarious liability to the temping agency that supplied the tortfeasor? And, well, no, but it can be. It just depends on more detail, really, which you have to look at the 5 criteria, is what I would say, and how it applies to the facts of the case. Because we all know that agency relationships differ. Some there is no control beyond placing them, some there is more control in respect to who pays who, what they're doing, whether it's for the benefit of the business, the agency business, or not. So I'm afraid about more information, anonymous attendee, I would be reluctant to say anything further on that front, which I think it takes up to about 5:30. So for my part, many thank yous to everybody who has listened, and to anybody who is foolhardy enough to have a look at the video of this. And if they have done and got to this far, then congratulations.
Thank you very much, and goodbye.
Bye.